Chapter 2 of the Risk Management Guide covers the mandatory standards that all CLCs must be aware of and comply with. It is very important that anyone commencing work in a CLC is familiar with this part of the guide. Volunteers and board members should also read through and understand Chapter 2. In this presentation, we will highlight the mandatory standards. We will also explain how some of the matters listed in Chapter 2 are then dealt with in more detail in later chapters of the guide. All members of a centre's management committee or board and all staff and volunteers, both legal and non-legal, should be aware of all the mandatory standards set out in this part of the guide. The first mandatory requirement in the guide is that each centre must appoint a responsible person to perform the role set out in the guide. This appointment must be in writing and the centre must advise their state or territory PII representative who they have appointed. The person appointed as the responsible person should be a centre employee who is a lawyer with an unrestricted practice certificate. Where this is not possible, the guide outlines the process that should be followed to appoint someone else as the responsible person. More information about the appointment of the responsible person is set out in Chapter 3 of the guide. The mandatory standards relating to insurance are simple. All lawyers must be covered by professional indemnity insurance that satisfies the statutory requirements in their jurisdiction. To ensure they are covered for all potential claims, centres must describe all services they provide in their initial application for PII and on the annual renewal application. These include any specialist, auspiced or hosted project, program or service. To be covered by the PII policy in the event a claim is made, a centre must notify the insurer in writing as soon as possible and while the policy is in force about a claim or loss and any facts or circumstances that might give rise to a claim. The process of making a notification is described later in this presentation. Any lawyer practicing as a lawyer at a CLC must be admitted to practice and have a current practicing certificate. If they are a restricted practitioner, then it is the role of the responsible person to make sure that adequate supervision, which will be prescribed by the local legal profession regulations, is provided to the restricted practitioner.
Hello, my name is Ria and I'm a solicitor at Welfare Rights and Advocacy Service. And one of my favourite sections of the Risk Management Guide would probably be the clear standards that are set out for supervision of the centre practice by the responsible person in Chapter 2. When I first started at Welfare Rights and Advocacy Service, I was a restricted practitioner back in 2016. So I was able to rely on the clear processes set out within this chapter of the guide to ensure that I was learning and understanding the processes of legal and non-legal work that were important, and most importantly the review process, and being able to rely on the feedback to grow and understand practice better. Since completing my restricted practice in 2018, I have also been able to rely on this chapter of the guide to be able to be confident in periods where the responsible person may be on leave, to be able to review and pick up any discrepancies in both legal or non-legal work of other staff in the centre, such as volunteers or fellow colleagues.
Any other professional working in the centre, whether as a volunteer or in any other capacity, is required to abide by the relevant codes of conduct for their profession in their work at the centre. This includes registered migration agents, financial counsellors and social workers. The Migration Act 1958 requires that a person who is going to provide immigration assistance must be registered as a migration agent. Again, it is the responsibility of the responsible person to ensure that anyone providing such assistance has the appropriate qualification. One of the most important obligations a centre has is to ensure they comply with their duty of confidentiality which is owed to each of their clients. Everyone at the Centre, including management committee members, staff and volunteers, are obliged to comply with all ethical, contractual and statutory duties of confidentiality. These duties are owed to all the Centre's clients, including clients of auspiced or hosted services or projects and branch offices. All statutory or contractual requirements for information privacy must also be complied with. Privacy laws exist at a state and federal level, and it is beyond the scope of this session to consider which of those might apply to a particular CLC, but it is worth noting that a CLC which would not otherwise be bound by the Privacy Act may be required to comply with various privacy principles under the terms of a funding agreement. If a CLC receives a request to disclose information about a client to a third party, such as a funding body, another service provider, or a court in response to a subpoena, and compliance with the request may breach confidentiality or privacy obligations, the responsible person should seek assistance from an experienced legal advisor, and if necessary, the PII representative, before disclosing any confidential or personal information about a client to a third party.
My name's Alice Pennicott. I'm the Managing Solicitor of the Tenancy Stream and one of the nominated persons at Circle Green Community Legal. Client confidentiality is really important for us. It's one of our mandatory standards under the Risk Management Guide, and it's also a fundamental obligation as lawyers under the Legal Profession Conduct Rules. It's a duty that we owe to all clients of our service, and it's necessary because a lot of our clients are often vulnerable and in highly stressful situations, and they want to ensure that their personal details and information will be kept confidential. This means they feel comfortable to provide full and frank instructions, and in turn, the legal advice that we provide can be relevant and accurate for their circumstances.
There is quite detailed information in the guide devoted to conflicts of interest to assist you in understanding the topic. This reflects the importance of understanding the steps that must be taken to ensure that a centre avoids conflicts of interest. In order to do this, it is necessary to understand what a conflict of interest is and the reason why proper conflict checking is required. It is also important to understand how to do a thorough conflict check. The guide provides assistance to centres where questions arise about whether or not a conflict of interest exists in a particular case.
Hello, my name is Rowan Kelly and I'm the Legal Practice Manager and the responsible person at Circle Green Community Legal. I've been asked the question, what is the one useful part of the Risk Management Guide that you find yourself referring to? I'd say that they are actually all incredibly useful. The one, though, I have personally got the most benefit around is 6.7 conflicts of interest. This is one of our fundamental mandatory standards as a law practice. I've found that the Risk Management Guide is incredibly useful in setting out both the overarching duties and obligations that we have as a legal practice. Also, though, addressing specific examples which come up frequently when working in a community legal centre. Things such as particularly dealing with a high volume of clients, as well as having a mixture of volunteer lawyers, paralegals and direct staff, dealing with secondment arrangements and a variety of other issues that we frequently come across on a daily basis. It's for these reasons that I find myself frequently referring to those sections when a curly question comes up that I need to resolve.
The mandatory standards include the following. A centre must avoid conflicts of interest and must have a policy dealing with conflicts of interest and conflict checking. The guide annexes a draft conflict of interest policy at Appendix G. Your CLC can use or adapt this draft policy. A centre has an obligation to train staff to identify potential conflicts of interest and to know what to do when one is identified. A centre must conduct a full conflict check before providing advice or commencing casework for a client. Have you seen your centre's conflict of interest policy? If not, ask to see it now and make sure you understand it. Where an actual conflict prevents a centre from assisting someone, the person should be told that the centre cannot provide a service and be referred appropriately. They should not be advised that a conflict exists, but simply advised that the centre cannot act for or assist them for ethical reasons. Each client file should indicate that a conflict check has been performed. The mandatory standards in paragraph 2.14 concerning practice supervision are relatively straightforward. These include the requirement that the responsible person ensure that all staff and volunteers are adequately and appropriately supervised. The responsible person must first form a view of the level of supervision needed for each member of staff and volunteer at a centre, including those in auspice services or branch offices, and then determine who is the appropriate person to provide the supervision. This may involve delegation of supervision of some staff to a nominated person who is suitably qualified. If you are not the responsible person at your CLC, do you know who is supervising you? For example, an employed lawyer with an unrestricted practice certificate and expertise in family law might be appointed as the nominated person to check the advice and casework of other staff and volunteers providing advice in family law. It is a mandatory requirement that the responsible person or a nominated person check all advice and casework of volunteers in a timely manner. A significant proportion of advice and casework of employed non-lawyers and a sample of advice and casework performed by employed lawyers on a regular, frequent and random basis. For this reason, in a centre that has a lot of workers, it is more likely that the responsible person will need to delegate some supervision tasks to others. Where incorrect or incomplete advice has been given to a client, the caseworker responsible must be alerted, the client given the correct advice, and the new advice recorded. Each worker should clearly understand the procedure to be followed if they become aware that a client has been given incorrect or incomplete advice. The responsible person must check all law reform submissions, media statements, and CLE materials produced by the centre prior to publication. There is more detail about supervision in Chapter 7. It includes a discussion about remote supervision and the supervision of staff and volunteers in branch offices. This is an area where the guide includes discussion of issues that may arise and suggested good practice. Client records may be paper records, electronic records, or a combination of both. The same rules apply to all these records. All client intake records must include the client's name, date of birth, contact details, date the instructions were received, the type of matter, the names of any other parties, and an indication that a conflict check has been performed. Client files should each have a unique file number so that all advice records and client files are readily retrievable. Legal problems must be recorded in sufficient detail so that the nature of the client's inquiry is clear. You need to record the advice or other information given to the client and any referrals made. The notes must contain sufficient details so that someone unfamiliar with the matter who looks at the record knows what has occurred. It must include the date and the name of the person who provided the advice or made the referral. Clients must be advised of all relevant limitation dates, and the fact that this advice has been given must also be recorded. Any limitation dates must be recorded on the file, and if it is an ongoing matter, the limitation date must be recorded in the centre's file review system so it is not missed. If a CLC provides advice by email or other electronic means, they must comply with all mandatory standards relating to the giving of advice by this means. This includes the centre having an email policy that takes into account the risk management issues that can arise. There is a draft email policy at Appendix F, and more detail is provided in later chapters. Have you seen your centre's email policy? How does it compare to the draft at Appendix F? A centre must not provide advice to a third party unless there are exceptional circumstances. Where the staff member or volunteer is not a lawyer, they must disclose this to the client. Many centres have paralegals or law students who may deal with clients. They should advise the client at the start of the conversation of their role, for example, by saying words to the following effect: "I am not a lawyer, I am a tenancy worker." There must be a record of each file in the centre's database, and this must include a record of when a file is opened and closed. Many centres use a database called CLC. In some jurisdictions, it is compulsory to have a letter of engagement or client agreement signed at the start of a matter. This is not required in Western Australia, however some centres use a letter of engagement or client agreement in all matters. Client files need to record relevant limitation dates prominently, including whether or not they have expired at the time the file is opened. It is also important to record any other critical dates, such as court dates, on the file and in a central location so that these are not overlooked. File notes must be made of all telephone and face-to-face attendances with the client or any other person spoken to about the matter. These notes must be attached to the file. Files need to include copies of all relevant correspondence and other documents. Importantly, a centre must ensure that client files remain confidential. This includes the obligation to keep any physical files in a secure location and to protect the client's electronic file by requiring strong passwords to access any computer. All centre data must be regularly backed up. Any mobile devices containing client information should be password protected, and portable data storage devices such as USB flash drives should be securely managed and stored. Before a file is closed, it must be reviewed by the responsible person or a nominated person to ensure that all requirements have been met. The client must be advised in writing that the file is to be closed and that it will be destroyed after 7 years, or as is appropriate for that file, and they should be advised of any relevant limitation dates. Any original documents should be returned to the client, and if applicable, any bills should be paid and all financial requirements met. The file's closing date must be recorded on the file and on the centre's central file register. Closed files must be archived in a secure environment away from unauthorized access for a minimum of 7 years. They should be archived in such a way as to allow access if this is necessary. You may need to look at a closed file to check potential conflicts of interest or take copies of documents for clients. Closed files can be stored electronically so long as a system of electronic storage satisfies the key requirements of reliability, integrity, and accessibility as set out in Section 12 of the Electronic Transactions Act. Once the file has been stored for the necessary length of time and before the file is destroyed, the responsible person must consider whether the client has given consent for the destruction of any documents in the file that are client documents. It is usually easier to obtain the client's consent at the beginning of the matter or when the file is closed than it is when it is time to destroy the files. Special considerations apply to the destruction of files containing instructions for wills and powers of attorney. A centre should consider when it is appropriate to destroy such files. This brings Part 2 of the Risk Management Guide to an end.